So today we're going to go over some more of the testimony of Chelsey Youmen, and she is going to be answering some questions by Representative Collier. Representative Collier is a very intelligent woman. We are not on the same side of the abortion issue, but she asks very good and very valid questions. So we're going to be talking today about the heartbeat bill again, and this is some of the testimony from the House of Representatives from the Health Committee. And what we're going to be dealing with today, Chelsey Youmen from, I don't want to say it wrong, Human Action Coalition, is going to be answering some questions about the legality and the enforcement of this heartbeat bill. So dealing with whether or not it's illegal for an abortion to be performed after a heartbeat has been found and how that will be enforced when it does happen. So she multiple times says that it will be illegal to perform an abortion after a heartbeat. And although it's illegal, the only course of action is going to be a civil private action. So although it may be called illegal, it's not going to be enforceable by law. And the abortion provider is the only person susceptible in this bill to the civil penalty. There is, and Chelsey Youmen is going to say this very clearly, there is no government action enjoined. In other testimony to another representative, she said that it's actually prohibited or excluded that, and I might be using the wrong word there. I don't want to use the wrong word. That the Attorney General cannot get involved. There's going to be no legal recourse. There's going to be no legal enforcement of this law. Only a civil penalty. So the questions that Representative Collier are going to ask are about the civil penalty and who can sue. Under this bill, it says anyone can sue. So Representative Collier is going to give the worst case scenario that people usually do when dealing with abortion. They go, what about in the case of rape? So rape is going to be the example that Representative Collier uses for her question. And rape is not the most common reason for abortion. It's less than 1%. Nonetheless, her question is very valid and it applies to any scenario for the abortion. So she's going to ask, the first question she asks is, how will the person that is going to sue have standing? And Chelsey Youmen gives a great answer. She says there is statutorily conferred standing for state court. So, well, that sounds great. We'll have standing. But she later agrees that there must be a preponderance of the evidence standard for knowing. So there must be evidentiary standards. What does that mean? That means if an abortionist performs an abortion on a baby with a heartbeat and I want to sue, or anyone else wants to sue, because there's not going to be any legal involvement for this illegal activity, it's just going to be a matter of lawsuits. So I have to have a preponderance of the evidence, what does that mean? So that means I need testimony. It means I need facts. I need documents, exhibits, and evidence. Now, keep all that in mind. Let's say I did have those things. Let's say this person I took to the emergency room the day before, and because they were feeling nauseous and they didn't know why, they had an ultrasound, found out that they're pregnant. Let's pretend they find out they're 17 weeks along. Their baby has a heartbeat. Okay, so we go to the emergency room. This baby is very much alive, and unbeknownst to me, the pregnant person goes the next day and begins the abortion process. Now, I think I have evidence. We were in the emergency room together and they left all their paperwork in my car. I actually heard the heartbeat and I happen to even have their paperwork in my hand. They've gone and aborted the child. And I decide that I'm going to sue the doctor because I know for a fact that that child had a heartbeat. I don't have to prove that the child had a heartbeat at some time. I have to prove that the doctor that aborted the child did not find a heartbeat when the person that went to have the child aborted procured this abortion. So how am I going to do that? How am I going to prove that a doctor aborted a child with a heartbeat and have evidence to sue them when they performed this illegal abortion? Now, the main point of the entire thing that I'm saying is that it doesn't matter. By the time all of this happens, the child is already dead. The child has already been murdered. What good is it going to do me to sue the abortionist for something illegal that the law doesn't even intervene or do anything on behalf of? How does that make sense? So here's the testimony. Thanks.
If the statute is enforced against an abortion provider, it's going to be by a private entity in state court suing the abortion provider, who may then raise all of the Roe defenses or constitutional defenses that they wish. But there's no government action to be enjoined by this statute.
Representative Collier.
I'm so sorry. I just want to make sure, how would they have standing to sue if they are bringing, because this is any person. Now, a court that's following the law is not going to let any person sue. They're going to say, you don't have standing to bring this lawsuit.
Sure. HB 1515 confers statutory standing, which in state court is all that you need. So in federal court, you're right, there are additional standing requirements, but a statutorily created standing is enough in state court.
Say, for instance, a person was raped, and this person went to go get an abortion, and there was no evidence whether there was a heartbeat or not, but the rapist wants to challenge it and wants to bring a civil lawsuit, and they would have the burden, is that right, to prove that there was a heartbeat under the civil code as a plaintiff.
Who is being sued in this example?
I guess the doctor, isn't that with the...
If a doctor knowingly performs an abortion on an individual with a heartbeat, it is illegal under this bill and susceptible to civil penalty.
Okay, but I have to prove that first because it's a civil case. So I have to file a lawsuit, right?
If you're suing the abortion provider, there's a preponderance of the evidence standard for knowing.
Right. So if I'm the rapist and I want to allege in my lawsuit that the provider illegally performed the abortion under your scenario of this bill, I can do that.
Well, I would hope if you're the rapist that you're in prison.
No, but this bill does not prohibit that.
This bill says that an abortion provider if they perform an abortion on a child in the womb with a heartbeat, that they are susceptible to civil penalty unless there is a medical emergency. There is a medical emergency exception in this bill.
So is rape a medical emergency?
There's no exception for rape or incest in this bill.
Well, then that doesn't, what you just said doesn't hold water. What I'm trying to figure out, if the rapist, even if they are in jail, this bill says any person can bring a civil action.
This bill allows for private enforcement.
So the rapist can sue the healthcare provider, the doctor, for performing an abortion which they believe there was a fetal heartbeat.
If an abortion doctor performs an abortion on a child with a fetal heartbeat, it is an illegal abortion under this bill.
And that means the rapist can file a civil lawsuit because you said any person. In fact, Representative Smith could even file that lawsuit.